In this video, I'm going to be covering off the changes which are proposed by the Employment Relations Amendment Bill 2018 that, if passed into law, will have some impact on bargaining for both employers and unions. Now, the first of the changes that I want to talk about relates to the initiation of collective bargaining. Currently, under the Employment Relations Act, both the employer and the union are afforded the same timeframes for initiating collective bargaining. The bill reintroduces the 20-day differential which applied 4 years ago to collective bargaining. This will effectively mean that the union can initiate bargaining within 60 days prior to the expiry of the collective, and the employer will have to wait till 40 days prior to the expiry of the collective to initiate. The intent of this is to give a wee bit more power, I suppose, back to the unions so that they can have the first crack at initiating bargaining. This 20-day differential will also apply to multi-union or multi-employer collective agreements, though the timeframes are a wee bit more generous than when you're talking about a single employment agreement between one union and an employer. The next change which I want to bring to your attention is in relation to the concluding of bargaining. Now, currently the Employment Relations Act provides for either the employer or the union to apply to the Employment Relations Authority to make a determination that bargaining has come to an end. Now, this bill revokes that ability and will put back into place a good faith requirement for collective bargaining to be concluded unless there is a genuine reason based on reasonable grounds not to do so. Now, when it comes to what's a genuine reason for not concluding bargaining, the bill doesn't state what a genuine reason might be. However, it does provide some good guidance on what a genuine reason is not. Well, opposing or objecting to collective bargaining or being party to a collective agreement would not be a genuine reason. Also, opposing or objecting to including the rates of wages or salary in your collective agreement would not be a genuine reason for concluding bargaining. And finally, disagreeing to including a bargaining fee arrangement in your collective agreement would not be considered a genuine reason for concluding bargaining either. This leads nicely into the next proposal in the Employment Relations Amendment Bill, and that is the requirement to include the rates of wages or salary in a collective agreement. There are three ways which the bill sets out that wages and salary may be included in your collective agreement. So the first of these is that it may just simply state what the wages or salary are that apply to certain work or types of work, or certain employees or types of employees. The second way is it may just set out the range of salary or wages for the work or the employees. And the third way is it may set out one or more methods for calculating the rates of wage or salary for the work, types of work, or the employees or types of employees. So what will be important for employers under this bill is that if your employment agreement does not include the rate of wages or salary, then it's not going to comply with the Act. So importantly, if this bill passes as it is currently written, if your employment agreement purports to determine that wages or salary is payable by solely referencing a document or a process that is not part of the collective agreement, then you're not complying with the requirement to have your rates of wages or salary included in your employment agreement. Also, if your process or your clause has some statement which makes it the sole discretion of the employer to determine how wages or salary are set, then that too will be considered not to comply with the proposed new requirement to include wages or salary in the collective agreement. Now, the amendment bill proposes to reintroduce the 30-day rule for new employees. This effectively will mean that new employees who are employed to undertake work or in positions that fall within the coverage of a collective agreement must be covered by the collective agreement for the first 30 days of their employment. So no term or provision of the collective agreement can be deemed to automatically alter after the 30-day period if in so doing it were to become inconsistent with the collective agreement. However, the bill does allow the employer and the employee to enter into variations to alter the agreement as they see fit after the 30-day period. So with the introduction of the 30-day rule, this bill states that the employer has certain obligations to the new employee. These obligations are about informing the employee that there is a union, that there is a collective agreement in place that covers the work for which the employee has been employed to do. They must inform the employee how to contact the union, that they're entitled to join the union, and that if they do join the union, that they will be bound by the collective agreement. They must also tell the employee that for the first 30 days their employment terms and conditions will be those set out in the collective agreement, and that they'll be bound by that collective agreement as if they were a member of the union. This means that the employer must therefore provide a copy of the collective agreement to the new employee. If there are more than one union covering the work for which the employee has been engaged, then the employer must provide both those collective agreements to the employee. The employer must also provide information to the employee about the role and function of the union or unions that operate in their workplace. So effectively what we're seeing in the changes to the bargaining arrangements which are proposed by the Employment Relations Amendment Bill 2018 is an unravelling of the changes which have been put in place over the last 4 years, and going back largely to the regime which applied around 2014. The only really significant change which is going to be addressed by this bill is the requirement to include rates of wages and salary in your employment agreement. So again, interesting to see how this bill plays out. It is now open for submission, and employers and individuals alike are encouraged to look at the bill and make their submissions on what they think about these proposed changes.